Judgment to like. অনলাইন করার ভালো কারেকশন সব দিতে লাগবে অনলাইন করার ভিতর দিব লাগবে কারেকশন writ petition dismissed
May I speak, Lordship? With due permission, Lordship, item number 12 and 15,
Yeah.
I have typically mistaken the name of the designation of the respondent of 5. So I may be allowed to correct it, my lord. 12 and 15.
what do you want to do you want to
No, I want to do it, but I want to correct your with due permission, your Lordship, the name of the designation of the respondent of 5.
how will you correct it in the system? Every petition file, the data goes into the central server.
Yes.
How will you correct it there? Think about it and tell me when your item is
So
called.
let it come on there Friday, or I do collect in the meantime.
You cannot do anything. You have to file an amended cost title or you have to withdraw and file afresh. That's those earlier days not possible now.
Not earlier that there is there.
Everything has a cost. So what do you want to do? You think and tell me.
I have to take it, man.
Do you think?
Made with the Lordship. I filed one IA on 16/6. That may be listed Lordship for.
What is the IA about?
IA is for allowing me to sit in an exam Lordship.
Huh?
Allowing the petitioner to sit in an exam Lordship.
When is the exam?
Exam is on 29th Lordship.
Wednesday.
Or Thursday Lordship. Wednesday is some difficult. On Thursday.
Lordship, I beg to pay before listing this matter for motion, Lordship. Lordship, in this case, Lordship, petitioner was serving his life without pension, Lordship, since last 19 months, Lordship.
So suddenly, why so much urgency?
Lordship, actually, he was serving as a driver in the
All
under
right, Wednesday.
Please, Lordship.
Lordship, I beg to mention for listing of a writ petition in the motion column. The matter pertains to pursuant of a recommendation by Central Pay Commission. The government of India has sanctioned a risk and hardship allowance for certain CRPF personnel deployed in specified areas.
Motion.
Motion. matter.
Thursday.
Yes, applies, Lordship.
I am withdrawing 12 and 15 and filing fresh today itself.
You understood the problem.
No. I am withdrawing both the petition.
I say, okay, but have you understood the difficulty?
I understand this well. I have asked my colleagues. So withdrawing it, filing fresh, let it be listed on Friday.
No, first you file it.
Yes,
Can't
today.
On
Today it's
the
filed.
request of Mr. B. Sharma, learned counsel for the writ petitioners, this matter stands disposed of on withdrawal with liberty to file afresh.
Fresh.
12 and 15 do it at the same order.
12 and 15.
After rectifying the defect in the writ petition.
Much
Yes.
obliged.
Please, Your Lordship, item 25, the matter may kindly be listed after vacation.
Sorry,
Item 25, the matter may kindly be listed after vacation.
you are for the petitioner. Your name, please.
I'm praying on behalf of Mrs. K. Devi.
On the prayer made by the learned counsel for the petitioner, admission hearing of this matter still adjourned for 3 weeks, list accordingly.
May I please? My lord, for motion, can it be day after tomorrow, my lord?
What is the matter?
My lord, in fact, now he sought to be terminated as a my lord, finance manager from the Skill University without, my lord, absolutely following the procedure of law, my lord.
May I please, Your Lord? I beg to mention item number 14. Lordship,
Yes.
kindly pass over the matter for the day.
Item number 14, motion.
Yes. Conducting counsel is out of station, Lordship. Mr. P. Sonwar.
Achha. On the prayer of learned counsel for the writ petitioner, motion hearing of this matter stands passed over for the day.
For withdrawal, item number 2.
I'd like to withdraw this,
Why you want to withdraw?
my lord, as the cause of action has been already, my lord. The salary was stopped due to the criminal offense was going on, procedure was going on, which was settled, my lord. I
Achha.
got a.
Mr. H.R. Chaudhary, learned counsel for the petitioner submits that during the pendency of this writ petition, the grievance of his client has been redressed. Therefore, the writ petition be closed. Ms.
We show your lordship.
V. Shore, learned counsel is present for respond number.
For lordship.
Respond number.
KAC on behalf of Mr. J. Chitty.
And who's
I am appearing for two lordships.
Achha, Ms. A. Bora, learned standing counsel, Health and Family Welfare Department, Assam for respond number 2. And any government advocate? Mr. D. Bora, learned G. Assam for respond numbers 1 and 5. কোথায় লোক এখানে? Who is for 3? None appears for respond number 3. Writ petition stands disposed of as not pressed.
Nice.
It is for motion, item number 3.
Yes.
The matter relates to not inclusion of the petitioners, my lord, in the old pension schemes. Actual message of this matter, my lord, that my lord, all the petitioners are appointed, my lord, before 1/1/2004, my lord.
So we'll issue notice.
Yes, my lord, at this time.
Right. But Mr. A. Sharma, A.K. Sharma, learned counsel for the writ petitioner, clears the amendments made in the writ petition. The petitioners herein are all former employees of within course Lokopriya Gopinath Bordoloi Regional Institute of Mental Health, unquote, bracket LGBRIMH, full stop. According to the petitioner, their retirement dues are covered under the old pension scheme, full stop. Notwithstanding the same, the request made by the petitioner to settle their pension about the old pension scheme has been arbitrarily rejected by the authorities. Hence this writ petition. Issue notice returnable in 8 weeks. Mr. A.K. Datta, learned CGC has appeared and
I
accepted,
am appearing on the 2 and 4, my lord.
has appeared and accepted notice on behalf of respond numbers. Your request for old pension scheme has been rejected,
Yes, not rejected, but it is pending before the central government.
has not been favorably considered by the authorities till date. Hence this writ petition rejected. Mein likho. Who's for respond number 1? You are not for respond number 1.
My lord, 3.
Huh?
My lord, I can.
Mr. A.K. Datta, learned CGC has appeared and accepted notice for respond numbers 1, 2, and 3, and Mr. D. Bora, learned G. Assam for respond number 4. You are appearing. Acha, 1, 2, and 4 koi diba, A.K. Datta, and D. Bora, G. Assam for respond number 3, service of notice. In completing this case, extra copies of the writ petition, requisite numbers be furnished to the learned departmental council so as to enable them to obtain instruction. You have not made the AG a party. You won't get any relief without the AG.
Item number 4.
Do it.
Yes.
What has happened to the appeal?
Is under consideration. So, my lord, lordship may direct me to dispose of this appeal, my lord.
Take down, heard Mr. S. Islam, learned counsel
Yes, sir.
for S. Hawk, learned counsel for the writ petitioner. Also heard Mr. S. K. Mehdi, learned CGC appearing for the respondents. Full stop. The writ petitioner hearing was serving as Constable BSF. Full stop. By order dated 12/1/2024, the petitioner was dismissed from service pursuant to a departmental proceeding initiated against him. Full stop. No, order dated 8/4/2024. What is the date of order?
My lord, what is the page 15, my lord? It is April, January 2024.
Acha, 12/1/2024. Being aggrieved by the impugned order of dismissal from service, the writ petitioner had preferred a statutory appeal before the concerned authority. On, when did you prefer the appeal?
8/4/2024.
On 8/4/2024. However, the appeal has not been disposed of till today. Aggrieved thereby, the writ petitioner has approached this court by filing the instant writ petition. Full stop. On 4/6/2025, this court had passed an order directing the learned CGC to obtain instruction and appraise this court as to the status of the appeal referred by the petitioner. Full stop. Today, when the matter is called up, when the matter is called up, Mr. Mehdi submits that the appeal is still pending and the same is under consideration. Therefore, he would have no objection if the writ petition is disposed of with a direction upon the authorities to dispose of the appeal in a time-bound manner. Full stop. Mr. Hawk, learned counsel for the petitioner, is also agreeable to such an order. Full stop. It is the admitted position of fact that the statutory appeal preferred by the petitioner is pending before
Before the, my lord, Director General, Quarters, BSF.
before the respondent number 2, that is the Director General of BSF. Full stop. In view of the nature of grievance expressed in the writ petition, as well as the submission made at the bar, this writ petition stands disposed of by providing that within 60 days from the date of receipt of a certified copy of this order, the statutory appeal preferred by the petitioner be considered and disposed of with a speaking order passed in accordance with law. If the writ petitioner continues to remain aggrieved even thereafter, it will be open for him to approach this court once again by filing fresh writ petition. Writ petition stands closed.
Number 5.
Lordship, instruction is awaited in this matter, Your Lordship. We have not received any.
When was he removed? When was he removed?
10/7/2024, DC directed the circle officer to conduct an inquiry within a period of seven days.
No, what is the order date of removal?
Was it 15/7? Also, he
15/7.
was not served with any the notice. Not.
All right, so he is not, will issue notice and fix it for admission disposal. But Mr. H. Agarwal and a counsel for the writ petitioner perused the amendments made in the writ petition. The grievance of the petitioner is pertaining to his removal from the post of Gaon Pradhan of lot number 11, Bamun Suburi under Bhairappada Moza, Tezpur Revenue Circle, falling in Sonitpur district. According to the writ petitioner, he was removed from the post of Gaon Pradhan without serving any notice or giving him any opportunity of being heard in the matter. Full stop. On 4/6/2025, this court had passed an order directing the learned standing counsel of the department to obtain instruction. However, today when the matter is called up, Mr. J. Hendik, learned SC Revenue Department, Assam, and Mr. D. Bora, learned G. Assam, have both submitted that instructions are still awaited. It appears that the petitioner was removed from the post of Gaon Pradhan on 15/7/2024. As such, this matter would call for deeper consideration. First, issue notice of motion returnable on 28 July 2025. Since Mr. Hendik has appeared and accepted notice for respond numbers 1 and 2, and Mr. Bora for respond numbers 3, 4, and 5. Oh, you have only 2. You are not appearing representing the secretary. Acha. Panchat.
PNRD, Mr. K. Kumar.
Acha. Mr.
Kumut Kod, K. Kod.
Since Mr. K. Kod and SC PNRD department has accepted notice for respond number 1, Mr. Hendik for respond number 2, and Mr. D. Bora and G. Assam for respond numbers 3, 4, and 5. Service of notice is deemed to be complete in this case. Extra copies of the writ petition requisite in numbers be furnished to the learned department council so as to enable them to obtain instruction. This matter again by reflecting the name of learned counsel for the respondents in the cause list. Considering the nature of grievance expressed in the writ petition, an attempt would be made to dispose of the writ petition at this stage of admission hearing. Parties to come prepared accordingly.
Number 6.
May please, your lordship.
Yes.
But after your lordship passed the last order, my lord, the private respondent, from then on, my lord, he has been sitting in the seat of the director. So, my lord, but there is no formal handing over of charge. Neither, my lord, I have been asked to hand over charge. And neither, my lord, we have been served with any unilateral order of taking over charge. That is the position, my lord. Let them file affidavit.
Lordship, my affidavit is being filed, Lordship. Therein, we have also enclosed the order, the private respondent joining the new post, Lordship.
When will you file it?
Today, we are filing, Lordship. It's being filed, Lordship.
And we'll have it on Thursday.
Lordship.
Heard Mr. M.K. Chaudhary, learned senior counsel appearing for the writ petitioner. Also heard Mr. P. Nayak, learned additional AG, Assam, appearing for the respondents, who submits that affidavit on behalf of the department is being filed during the course of the day. On the request of Mr. Nayak, let this matter be listed again on 26th of June 2027 for motion by taking the affidavit in the record of this case. Interim order passed earlier to continue.
Number 7.
May it please your lordship. But regarding transfer, my lord, your lordship kindly see, my lord, it in
Has the approval of Chief Minister taken?
Yes, Lordship.
Can you show it to him once?
Your lordship kindly see before that, my lord, when approval is not the question, my lord. Question is that, my lord, your lordship kindly see that, my lord, annexer, my lord, 4, my lord. Yeah, while moved the, my lord, proposal has been given, by while moving the proposal, my lord, the proposal contain what public interest, my lord, involved. That has to be mentioned, my lord. So your lordship kindly. that is
Mr.
the mandate of
Mohanto,
the-
a very astute lawyer like you will always make out a good case everywhere. But you know, in transfer matters, the jurisdiction of the writ court is very, very limited.
Correct, my lord.
So some cosmetic defect here and there.
No, my lord, why your
Will
lordship
always
kindly
be
see,
there.
Supreme Court is very clear on that point, my lord. MLA and minister cannot, my lord, cannot give the proposal, my lord. Proposal always from the department. And department, my lord, that is a very clear judgment of the Honorable Appeals Court, my lord.
It's a series transfer.
My lord,
Number of transfers have taken place.
My
Only
lord.
one transfer on many.
is it one transfer? No, only my lord.
Where is the order, transfer order?
Annexer 2, my lord, page 21. Page 21.
Yes.
Page 21. So now, my lord, your lordship kindly see. Annexer 4, your lordship kindly see. That is the guidelines frame, my lord. That is also framed under the supervision of the Supreme Court, my lord.
No, in this you want to refer to which paragraph?
My lord, paragraph
Paragraph?
4 and 5, my lord. 5 and 6, my lord.
There is no 4 and 5 here.
No, sorry, 5 and 6, my lord. If the department says, my lord, department head says there's a public interest demand, it should be transferred, my lord. I have no case, my lord. That's why, my lord, annexer 4, page 24, my lord, your lordship kindly see.
So it only says if MLA recommends the views of the department must be obtained. That's all.
Yes, my lord, department head has to be, my lord, place the proposal, my lord. These are the public interest litigation, my lord.
Yes, give me the record. I'll go through it and pass on.
These are printout of the computerized records, Lordship.
No,
This-
that's okay.
Lordship, if Lordship comes to page 12, Lordship.
Is there a pagination here? Page 12 of?
page 12 of the writ petition, Lordship.
Yes.
Paragraph 14, Lordship. These are the grounds of silence, Lordship. Now, Lordship may kindly see where it has been pleaded that on the proposal initiated by the MLA or minister, transfer cannot be initiated. Where is the ground?
Maybe not on like other grounds. Are
Then-
there.
Yeah, just a minute, let me.
Clause number 5 is very clear. Clause 4 and 5. One and
MLA minister দেখা নাই।
what the hell?
No, you are saying this transfer was affected by the approval of the chief minister.
Approval is there, Lordship.
Where is it?
This is the approval, Lordship. One
Page number?
page number, it has not been paginated, but Lordship, it is the 5th page from the last, from the end, Lordship. 1, 2, 3, 4, 5th, Lordship.
Yes.
That is the approval, Lordship. Now, if Lordship comes to page 18 of the writ petition, Lordship. Lordship, he is posting at Guwahati, Lordship, on promotion. It was an order dated 13 August 2024. If Lordship comes to this order, Lordship, as per recommendation of the selection board, in its meeting held on 6/8/2024 and subject to reversion without notice and without assigning any reason thereof, and in the interest of public service, the following officers now working in the rank of Superintendent Engineer Civil on the Irrigation Department are promoted to the rank of Additional Chief Engineer Civil in the scale of so and so with grade pay so and so plus other allowances as admissible as per rules, and on promotion are posted on temporarily. Lordship, immediately after promotion, he has been posted temporarily at Guwahati. Now, Lordship, this is the regular transfer, Lordship, that has been proposed by the minister. Accordingly, it was processed. Ultimately, Chief Minister given approval, and thereafter the transfer order was issued. So that is the background, Lordship. Now, coming to law, Lordship, 2-3 judgment, Lordship, I'd like to place, Lordship. Lordship, first one is 2004-11 SCC 402. So at paragraph 7, Lordship. Paragraph 7, page 406.
Yes.
Paragraph 7, it is too late in the day for any government servant to contend that once appointed or posted in a particular place or position, he should continue in such place or position as long as he desires. Transfer of an employee is not only an incident inherent in the terms of appointment, but also implicit as an essential conditions of service. In the absence of any such indication to the contrary in the law governing the conditions of service, unless the order of transfer is shown to be an outcome of a mala fide exercise of power, or 2, violation of any statutory provision or act or rule, or passed by an authority not competent to do so. So these are the 3 grounds, Lordship, on which a transfer order can be silenced, Lordship. Not a single one has been made ground, Lordship, in this case. If Lordship comes to the judgment, Lordship, that has been passed by our High Court, Lordship. This is WPC number 4124. 4124/2024. It's a division bench judgment, Lordship.
Yes.
Lordship was also there in paragraph 18. Paragraph 18. From the above decisions of the Honorable Supreme Court, it is settled that a transfer of a government employee cannot be interfered with solely on the ground that the same is in violation of transfer policy. In such circumstances, we are of the view that the interference by the tribunal in the transfer order of the private respondents on the ground that the same is in violation of transfer policy is not liable to be sustained. Similar judgment was there, Lordship, in next one, Lordship. This is 2005 SCC online Guwahati, Lordship, 97. Digantovia versus State of Assam, Lordship. Paragraph 27, Lordship. Paragraph 27. An employee holding a transferable post cannot claim any vested right to work on a particular place as the transfer orders does not affect any of his legal right, and court cannot interfere with a transfer posting which is made in public interest or in administrative exigency. The government instruction on transfer policy are mere guidelines without any statutory force, and the court or tribunal cannot interfere with the order of transfer unless the said order is alleged to have been passed by malice or where it is made in violation of the statutory provisions. Fourth one, Lordship, that is 2006 9 SCC 583, paragraph 6, Lordship. Paragraph 6. We have perused the record with the help of the Learned Counsel and heard the Learned Counsel very patiently. We find that no case for our interference whatsoever has been made of. In the first place, a government servant cannot disobey the transfer order by not reporting at the place of posting and then go to a court to ventilate his grievances. It is his duty to first report for work where he is transferred and make a representation as to what may be his personal problems. This tendency of not reporting at the place of posting and indulging in litigation needs to be curbed. Apart therefrom, if the appellant really had some genuine difficulty in reporting for work at test.
All right, I've seen it, yes.
So these are the basic judgment, Lordship. Two judgments, Lordship, with permits, Lordship, I can also place whether at the initiative of an MLA or a minister, Lordship, transfer can be processed or not, Lordship. Two judgments, Lordship, I place, Lordship. It was not a ground there, that is why.
No, it is not processed at the instance of MLA. Is that the case?
Yes, Lordship, not by MLA.
Is that your?
No,
is
my
that-
lord, my case is that, my lord, department, my lord, department head, your lordship, I have judgment, that judgment I have 2015 judgment I have annexed, I have submit, my lord. My lord, department head has to, my lord, process the initial process has to started by him with a proposal that public interest demand, so he has been transferred.
So that is what has been done here. That's what I'm
No, my
asking.
From department, if there is a, from department, if there are
Oh,
any.
the minister of the department. has-
No, my lord. Minister, my lord, department cannot, minister, that is why your judgment is very clear, my lord. The minister and MLA cannot. That from the head
Okay,
of the
you are
department.
saying even the department and minister cannot have a say.
Yes, my lord, that it is the mandate of this judgment, my lord. That is my submission, my lord. If the, my lord, proposal has been given by the department head, my lord, very clearly in paragraph 6, my lord. is
The
clear.
minister is the department head.
No, my lord, yet here.
Show
my
me a
lord, here-
judgment which says
Here,
no.
my lord, clearly, my lord, your lordship kindly from the, your admin, not from the legislature, your lordship kindly see.
Hmm.
If department demand that, my lord, I want to, my services, public services, is in the interest of the public, my transfer is
Have
required,
you-
then, my lord, I am.
Have you seen the record? Do you
No, my
want to
lord,
see
is
that page?
For your lordship, my lord, I have not
That's
seen.
for
my-
your satisfaction.
No, that's your lordship says, my lord, everything. But my submission before your lordship is, my lord, that department head.
That's
Department
right.
Head mean, my lord, the administrative head, my lord.
What order will be passed is another thing, but I want you to have a look at this.
No, that's all, my lord. Your lordship has gone through it, my lord. I'm satisfied. I'm not on that. I'm not on that, my lord. I have no
Mr.
need to, my
Mohanto,
lord.
your
No, my
satisfaction
submission
is
is, my
important.
lord. My lord, at the head of the department, it means, my lord, as per this judgment, my lord, that is, my lord. I'll leave it to your lordship. I'm not going to that.
No, no,
I'll
please,
leave it to your
please,
lordship, no?
please have a look at it.
No, that minister, my lord. My lord,
Minister has no power.
as per this judgment, my lord, no power. That, my lord, that.
All right, let us slip, give the appearance slip. Order reserved.
My lord.
Lordship permits lordship to judgment, I can also place on that issue only, not required.
Get the order in the evening. or
Lord.
tomorrow morning.
May it please your lordship. Lord, although an order of withholding of one increment with cumulative effect has been imposed upon the petitioner, I am praying for stay of that particular order. Because firstly, it is absolutely case of Miller, no misconduct. Secondly, the charges were absolutely vague. Milord, what happened in this matter, Milord? The Director of Audit Local Funds directed the petitioner to conduct an audit of Kherasghat College, Lakhimpur for 3 years, 4 years. He conducted the audit and he submitted 2 preliminary objection statements which contain Milord, materials to demonstrate that the principal of the college was involved in embezzlement of money. Now, that particular principal lodged a complaint before the commissioner saying that the audit was not done properly. And that complaint was forwarded by the APSC chairman, the then APSC chairman, who has got no business into this. After that, a departmental proceeding was initiated, 3 charges.
Right, we'll issue notice on main and interim prayer both.
Lord, the penalty of withholding of one increment has not been implemented yet. It will be implemented.
We are
in
issuing
July.
notice on both.
Hello.
Huh? Let them come up with their response. This order was passed in September 2020.
That's true. Thereafter appeal I have preferred and appeal got rejected.
All right. Heard Mr. H.K. Das, Lawyer Counsel for the petitioner. Peruse the statements made in the writ petition. Being aggrieved by the order of penalty dated 12/9/2024, wherein the penalty of, within quotes, withholding of one increment and warning, unquote, had been imposed upon the petitioner, as well as the subsequent order dated 5/4/2025, passed by the appellate authority, dismissing the appeal referred by the petitioner. The instant writ petition has been filed, inter alia contending that the entire departmental proceeding is vitiated due to procedural irregularities and violation of principles of natural justice. Stop. Mr. Das, learned counsel for the petitioner, has also prayed for an interim order suspending the operation of the impugned order by urging that the order of penalty has not yet been given effect to. Full stop. You are appearing. Mr. P. Nayak, learned additional AG, Assam.
1, 2, and 3, Lord.
Appearing for respondent numbers 1, 2, and 3. Has however prayed for some time to seek instruction in the matter. Issue notice of motion returnable on 30th of July 2025. Since Mr. Nayak has accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition requisite in numbers may be furnished to the learned departmental counsel so as to enable him to obtain instruction. Heard on the prayer of interim relief, this said prayer will be considered on the returnable date. The respondents to file their affidavit on the prayer of interim relief on or before the returnable date. It is made clear that any action taken in the matter during the pendency of the writ petition will be subject to further order that will be passed in this case.
Much over.
Item number 9.
May I please your lordship? What's the grievance of the petitioner that I have not been received fire risk allowances from March 2024, lordship. Was the petitioner presently working as a
Will issue notice at this stage. Issue notice. Third, Mr. P. Gohai, Learned Counsel, appearing for the writ petitioner, peruse the amendments made in the writ petition. Full stop. The petitioners are working as constable, fire, and are posted in the CISF units under the BGTPP, Salakati, in the district of Kokrajhar. Aggrieved due to non-consideration of their prayer for release of fire risk allowance, which according to the petitioners have been permitted to similarly for in case of similarly situated employees posted at NHPC Zakri, JHAKRI, in the state of Himachal Pradesh, the present writ petition has been filed seeking a writ of mandamus. Mr. Ms. K. Fukar, Learned CGC, appearing for the respondents, has prayed for some time to obtain instruction in the matter. NOM 6 weeks. Since the respondents are already presented, no formal notice, extra copies.
Oblige.
number 10?
Yeah, please, your lordship. My lord. My lord, penalty for stoppage of 2 increment cumulative effect, my lord, page 58, my lord. Operative part is 59, my lord.
Will issue notice at this stage. Third, Mr. I.A. Talukdar, Learned Counsel, appearing for the writ petitioner, peruse the statements made in the writ petition, assailing the order dated 23/4/2024, by means of which penalty of stoppage of 2 annual increments had been imposed upon the petitioner, as well as the subsequent order dated 25/1/2025, passed by the appellate authority rejecting his appeal. The instant writ petition has been filed by the petitioner, entirely contending that the impugned orders are vitiated by complete arbitrariness and illegality. Mr. D. Bora, Learned Government Advocate Assam,
All
waits
the
for
respondents.
some time to obtain instruction in the matter. NOM 8 weeks. Since Mr. Bora has appeared for all the respondents, no formal notice is required to be sent. In this case, extra copies of the writ petition requisite in numbers be furnished to the Learned GA Assam to obtain instructions.
My lord, appellate order is 21/1/2025.
You have written 25/1. In your synopsis, you have written 25/1.
My lord,
Huh?
yes, 25 more.
What is the correct date, Mr. Bora? 25 or 21?
21.
21.
21.
21/1. So why have you written,
21/1.
Page 59. 21.
21/1.
why have you written 25/1?
My lord, it is written 21/1/2025.
21/1.
It's not so widow wife. She's entitled, but some.
Oh, what is this? What are you doing? How can all these things be done?
This has been done at the
What does
expense
that
of
go to
the
do?
treasury official, lordship. The allegation is against the treasury official, lord.
No, but who is for the finance department? You please call Mr. Nayak. These are all absolute harassment. You wait. Let the additional AG come.
Number 13.
Make it. Lord, petitioners in this present case, they joined my lord PWD department as junior engineers. And my lord, they acquired the requisite qualification for promotions, my lord.
We'll issue notice at this stage. Your synopsis is too long. Lot of things you have.
My lord,
Lot of
because
difficulties.
This is the third line of litigation, my lord.
It will happen
they-
when you write such long synopsis. Third, fourth, fifth is bound to happen. But I'm issuing notice at this stage.
Only, my lord, the promotions, they were given the promotion with retrospective effect, my lord,
Hmm.
by this honorable court, my lord. And that order is also, notification was issued. Subsequently, my lord, this notification again, my lord, this seniority list was published, my lord, wherein their promotion has not been considered, my lord, from retrospective effect, my lord. That is my grievance, my lord.
What is the order you want today?
My lord,
What order do you want
the
today?
interim, my lord, the, my lord, the, that, seniority list, my lord, may not be, my lord, given effect during the pendency of this case, my.
Is something happening? Is there a
My lord,
promotion?
yes, my lord, the promotion is, my lord, as per my instruction, it will be, my lord,
Notice may
effective.
be issued.
We'll issue notice on both.
My lord.
Heard Mr. M. K. Das, counsel for the petitioner, peruse the amendments made in the writ petition. The dispute raised in this writ petition pertains to gradation list in the cadre of assistant executive engineer in the PWD roads and buildings both.
My lord.
Roads and buildings both.
Together it came, my lord, common.
Roads
order,
and
my lord.
building.
But
According to the
we have
petitioner,
provisions, my lord.
due to retrospective promotion given to, who was given retrospective?
We were given retrospective effect from the year.
After the
2015.
retrospective effect given to the promotion of the petitioner and other similarly situated officers, the gradation list has not been rectified in accordance with law, hence this writ petition. Mr. Das has also prayed for an interim order restraining the respondents from giving effect to the gradation list published on
Page 44, my lord,
March
March 2025.
Published on, what is the date?
My lord, that is notification number PWRD/CON/ECF number 2945.
Published in the month of March
March
2025.
2025.
Miss, your name please?
Toshisan,
Miss Toshi Lane, counsel appearing
respondent 234.
on behalf of Mr. R. Dhar,
Yes, Lord.
Learned SC PWD, prays for some time to obtain instruction in the matter. Petitioner, plural. NOM 6 weeks since Miss Toshi has appeared in, since Mr. D. Bora Lanet G. Assam has appeared in accepted notice for respond number 1 and Miss Toshi for respond numbers 2 to 4. Service of notice is deemed to be complete in this case. Extra copies of the writ petition requisite in numbers be furnished to the learned department counsel so as to enable them to obtain instruction. Hard on the prayer of interim relief. Issue notice on interim prayer as well. The prayer for interim relief will be considered on the returnable date. Parties to come prepared accordingly.
Deeply obliged.
Sixteen.
Who is appearing?
The K.N. Chaudhary.
We will pass it over for 20. Yes. Next.
He is here, your lordship.
Huh?
Petitioner is here. Perhaps he did not place it here. 16. Yes, sir. 16.
Yes, sir.
I'm sorry, Lordship. Lordship, we have challenged the entire disciplinary proceedings. Penalty of dismissal has been passed against us, whereas it was a case where not even the departmental inquiry was required, Lordship. I was initially arrested on apprehension. Subsequently, the police report itself says that no fault was found with me. So I'm challenging the show cause notice as well as the inquiry report and the dismissal, Lordship.
Where is the order of dismissal? Page number?
Dismissal is at page number 111, Lordship. The show cause as well as the dismissal order, Lordship, no specific allegation. It is a very vague and general order, Lordship.
What is the date of the order of dismissal from service?
The date is, Lordship, 27/5/25. Down below, Lordship, right side.
All right. We can only issue notice at this stage.
Mr. K.N. Chaudhary is appearing in the case, Lordship. Perhaps he's on legs, Lordship. I'm appearing on.
Yeah, then I'll record your name.
Lordship.
Heard Mr. D. Sarav, Learned Counsel appearing for the writ petitioner, peruse the amendments made in the writ petition, being entirely aggrieved by the order of dismissal from service dated 27/5/2025. You want me to record the name of Mr. Chaudhary?
Lordship.
Achha, Mr. K.N. Chaudhary, assisted by Mr. Senior Counsel, assisted by Sons. Entirely aggrieved by the order dated 27/5/2025, issued by the respondent number 3, imposing the major penalty of dismissal from service on the writ petitioner. The instant petition has been filed, inter alia contending that the impugned order is vitiated by complete arbitrariness and illegality. The learned senior counsel for the petitioner has further argued that no proper opportunity was given to the petitioner to defend his interest during the departmental proceeding. Stop. Mr. S. Dattal, and Standing Counsel, Revenue Department, Assam, and Mr. D. Boral, and G. Assam have both prayed for some time to obtain instruction in the matter. NOM 6 weeks. Since Mr. Datta has appeared and accepted notice for respond number 1 and 1 and 2. You are appearing for 2 also?
No.
Home Department also? Oh, 1 and Mr.
One,
D.
one.
Boral and G. Assam for respond numbers 2 to 7. Service of notice is deemed to be complete. In this case, extra copy of petition requisition number be furnished to the learned department council. So it's
Notice can be issued on interim relief also.
heard on the prayer of interim relief. Issue notice on the said prayer as well. Returnable in whatever is the time.
Like Lordship.
Binding item 11.
Mr. Nayak, have you seen this matter?
Lordship, some confusion is there, I think, Lordship. Otherwise, to my knowledge, Lordship, persons, even under NPS scheme, Lordship, compassionate family pensions are allowed. That is my understanding.
There is a judgment of this court also, recent
Yes,
judgment.
it is notifications are there, Lordship. So I think some miscommunications or misunderstanding is there, Lordship. If Lordship comes to paragraph 7 also.
Right, you are right. But what can be done now?
Lordship will allow me to have instruction, Lordship.
Day after tomorrow?
It's from which district?
Thursday?
From Lokhimpur.
Thursday?
Thursday, Lordship, Thursday.
Mr. M.J. Varun and counsel of the petitioner is present on the request of Mr. P. Nayak, London Additional AG, Finance, bracket State of Assam. List this case for motion again on Thursday, date to the 26/6/2025 for motion.
Instruction to the extent whether wives are entitled to family pension or not, who are under.
Wives are entitled to, he says the ground on which she was declined is that the treasury officer told you take the CPF dues, and she took it, and now they are saying because you have accepted the CPF dues, you are not entitled to compassionate family pension. But that is a totally preposterous ground. Compassionate family pension is a part of a scheme.
Yes.
If a person is entitled under the scheme, you have to give it. That has nothing to do with what are other benefit. If a person has worked for 15 years, he will have some retirement benefits. But that cannot be a ground to deny compassionate family pension. Where is the notification to deny that?
Yes, in the notification, nothing.
Then why, if the allegation is correct, this is a very wrongdoing. So you please find out
Yes,
whether this allegation is correct or not. If it is correct, then we'll pass orders.
Lordship.
All right. 2 extra copies of the writ petition be furnished to Mr. Nayak during the course of the day. So and so and so and so are present. Mr. N. Upadhyay and Mr. ST Irrigation Department and Mr. R. K. Bora. You have 4?
For vessel 4 year.
Just you look into the matter. There should not be harassment to people of this condition. That's the point. Just by litigating, it serves no purpose. If there is a scheme to help them and if they are coming within the fold of the scheme, then by taking this ground and that ground, denying them is not.
Lordship, so far as minor, that is why I'm repeating, Lordship. Even persons under covered by new pension scheme are also entitled to compassionate family pension.
So
in
why?
this case, Lordship, what happened? That instruction I will try.
Yes. That's
Step number 17.
Here the petitioner was working as an assistant conservator of forests. He's agreed because he's.
Well, he was sleeping over his right. Who can do what about it?
What happened is.
Everybody else submits APR and he says, I didn't know. We'll issue notice returnable in 8 weeks. Mr. No, these are absolute. What kind of an explanation is this? The entire department knows that annual, and he has never got a.
Just before sending the names, everybody was individually informed that you give it to us. No one had given it on the limit within the time period. Before sending the names, everybody was intimated. Only I was not intimated.
Why is that? Why?
If they can show that one letter which I have given here contains all the
correct.
names.
That everybody was individually.
I don't have that instruction today.
Yes. After tomorrow, you tell us. Heard Mr. R. Majumdar, learned counsel for the writ petitioner on the request of Mr. P. N. Goswami, learned additional AG, bracket Forest, is it? Forest, bracket to Assam. This case again on Thursday, we'll put it on 26th as fixed item for motion, so as to enable him to obtain instruction with regard to the allegation made in the writ petition that while every other departmental official was individually informed, asking them to send the APR, no such intimation was given to the petitioner. Mr. Goswami to obtain written instruction from the competent authority on the aforesaid point on or before the next date fixed. 2 extra copies will give him. 2 extra copies of the writ petition will be furnished.
Then number 18. Your Lordship. Lordship may kindly pass over the matter for the time being. I still engaged counsel is on legs in court number 24. Yes. Lordship. Then number 19.
Wait, please, your lordship. In
Yes.
this matter, the petitioner is working as a storekeeper in the ITF. Both the petitioners. There, what has happened, your lordship? Actually, their ROP, rules of ROP on 2017, their rate pay was fixed at 6,200 in 2017 itself. And they are drawing the rate pay of 6,200 from there. And
Where is the order of recovery?
that, your lordship, will find the impugn order at page 62. Suddenly, out of the blue, after 8 years, they have come up saying that I'm not entitled to grade pay of 6,200, and they have reduced it to 5,600. And now they have, secondly, your lordship, the most important part is that from May, they have totally, my name has been deleted from the pay roll itself, and my salary has been stopped. So there are two prayers, your lordship. First and foremost is that they cannot reduce my pay scale without giving me any notice or something. And secondly, your lordship, they cannot stop the pay altogether. These are the matters. Second, your lordship, there was an issue of the excess amount to be recovered. That part, your lordship, will obviously come later on. But as of now, they have totally stopped my salary from last month. And secondly, this order has been. These are the two issues, basically. And in fact, your lordship,
Salary for which month has not been paid?
from the last month. It was, the order was issued in May, and May itself, from May itself, they have not even the name of my name in the payslip has not been incorporated, and thereafter I have not been. And not even paid a salary. Not the reduction. Part
Yes,
is a different part.
Mr. Bora?
Your Lordship, here, for the directorate, there is a standing counsel, Mr. SP Das.
Hmm.
He is the standing counsel for Directorate of Employment and Craftsman Training. His name is not shown, perhaps.
SP Das will be here in next 10 minutes. You wait.
I'll have
He has
to
got
call-
some matters in the list.
I'll have to call him.
No, he will come. His items are listed.
Right.
Please wait. We'll ask him.
Number 20.
Right, please, your lordship.
Yes.
My lord, in the earlier round of litigation, if your lordship would kindly come to page 39.
Hmm.
Para 13, my lord. Towards the bottom. It is to be noted herein that under rules of 1964, an order of major penalty cannot be imposed upon a government servant without following the procedure prescribed under Rule 7 and 9 of the rules. Moreover, as per Rule of 1964, it is the disciplinary authority which can alone initiate a departmental proceeding against a government servant and thereafter impose penalty. There is no dispute at the bar that the Deputy Commissioner Nalbari was not the appointing authority of the petitioner, who was serving as an executive engineer in PH in Nalbari division at the relevant point of time. Therefore, the action initiated by the Deputy Commissioner Nalbari cannot be treated to be an action initiated within the meaning of Rule 9 of the Rules of 1964. Insofar as the show cause notice dated so and so is concerned, it is no doubt correct that the said show cause can be treated as a notice initiating departmental proceeding against the petitioner. However, this court has noticed that before initiating such departmental proceeding, petitioner was not given an opportunity to explain his conduct. Failure of the departmental authorities to give an opportunity to the petitioner to explain his conduct in the considered opinion of this court indicates a predetermined mindset of the authority to come to a conclusion even before holding a proper departmental inquiry on the charge of misconduct brought against the petitioner. Permitting such a recourse in the opinion of this court would not only run counter to the scheme of Rule 9 of the rules, but would also amount to extending complete unfair treatment to petitioner. Lordship may kindly come to para 16. For the reasons stated herein above, this court is of the opinion that the impugn order of dismissal from service is vitiated by arbitrariness and illegality. This same is accordingly set aside. Consequently, writ petitioner shall be reinstated back in service forthwith. However, having regard to the peculiar facts and circumstances of the case and the nature of allegation brought against the petitioner, this court is of the opinion that facts of the case do not justify exoneration of the petitioner on such technical ground without subjecting him to a proper inquiry proceeding. As such, the department is granted liberty to initiate a fresh proceeding against the petitioner from the stage of issuing a notice upon the petitioner to explain his conduct. My lord, this notice has been misconstrued by the department as a show cause. Now please come to next para 17. If such explanation to be furnished by the writ petitioner is found to be unsatisfactory, it will be open for the disciplinary authority to drop a disciplinary proceeding against him as per law. Since petitioner is due to etc. So, my lord, what your lordships felt that deputy commissioner nobody is not the disciplinary authority. If something has been done at his instance, it cannot be comprehended within the contour of power under Rule 9 read with 7. Therefore, my lord, everything was set aside and liberty was given to the department to start an inquiry. Why? Which inquiry? Prior to the stage of initiation of a disciplinary proceeding. Now what they have done, my lord, they have issued the show cause at page 43. Straightway they have issued a show cause under Rule 9. But what your lordship directed was an inquiry will be conducted, a notice would be given, basically a preliminary sort of an inquiry to explain his conduct. If upon such a response, my lord, the authority is satisfied that no, it's a case which one should go for disciplinary proceeding, then they could have gone. Now they have straight away issued the show cause notice under Rule 9, which lordship never permitted. What lordship permitted was that let them seek an explanation, then form an opinion whether it's a case for disciplinary proceeding. But this is my case.
Yes.
It's true, my lord, direct, they have issued a notice on so-called notice under Rule 9. But my lord, subject to correction, my lord, paragraph 13, my lord had taken note of the rules, my lord, Rule 7 and 9. And my lord, in Rule 7 and 9, there is no scope for my lord preliminary inquiry. And my lord, there was already an inquiry
No,
report.
but then this judgment, then you can't go against the judgment.
True, my lord, true.
So
Perhaps,
there are two things. You can either withdraw it and
yes,
issue a notice,
yes.
or I'll stay it because I may not have time to deliver a
My lord,
judgment.
may post it on Thursday or Friday, I will impress upon my client.
No, Wednesday.
Wednesday will be too early for me, my lord, because
Maybe.
tomorrow, my lord, I will be out of station. My lord. Wednesday evening, I will come back. Thursday or Friday, my lord.
Okay.
Because, my lord, it is true, my lord, there is specific order from your lordship to ask for an explanation. That has not been done. But under the rules, my lord, there is no scope for explanation.
So you see, the order was passed in the context that earlier he was proceeded against in a hot haste.
Yes.
So to eliminate the chances of any bias, as judges in 226,
Definitely, my
we
lord,
will only look into that.
My lord, definitely can.
There are allegations of bias. We will only protect to that extent. So now the court says, first hear him and then take a decision whether you should proceed. You proceed. The order is illegal. We'll have to either set it aside, but
Thursday or Friday, my lord, I will try that. It is,
otherwise we'll stay. There's no way out. Thursday?
Then they will not act on it.
that's my
No, they will not.
undertaking, my lord. They will not do anything. Today itself, I will talk to them. My lord.
Yes. See, tell them to
Yes,
understand now.
I got it, my lord, because explanation was not.
There is no requirement, but then
It was directed.
this preliminary inquiry
was
are
directed.
held.
My lord,
Yes.
your lordship has not spelled out in the order the view is correct. Why I am saying so, my lord. If there is a preliminary inquiry and in the preliminary inquiry the delinquent is not involved or no notice is
Why should
given,
we subject him?
because that cannot be a subject matter. That cannot form the basis for DPC.
Correct,
DP, my
correct,
lord.
correct.
And moreover, sometimes what the disciplinary authority does, my lord, they rely upon the preliminary inquiry report. Supreme Court says you can't do, the proceeding itself goes. That's the reason.
A preliminary inquiry report, if
No, cannot-
accepted, if relied upon by the authorities, the petitioner is entitled for a copy of that report. My lord.
No,
There are
what I-
judgment to
no,
that effect also.
No, I'm saying on the other way, if in the preliminary inquiry or any inquiry which precedes the disciplinary inquiry, if the delinquent is not associated with then that cannot be used in the disciplinary procedure.
Absolutely.
That is one.
True.
But that the preliminary inquiry is there. So we don't know how the outcome of the
influenced.
preliminary, how it has
I got
influenced.
it, madam.
There's no. Heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. D. N. Bhattacharya, Learned Counsel for the petitioner. Also heard Mr. P. N. Goswami, Learned Additional AG, PHE Department, Assam, who seeks posting of this matter again on 26/6/2027, so as to enable him to obtain specific instruction from the departmental authorities facilitating disposal of the writ petition at the motion stage. 2 extra copies of the writ petition be furnished to Mr. List accordingly.
Item number 21.
Yeah. My lord, I am VC because of medical reason.
Ah, okay.
My lord, this is a petition, my lord, where, my lord, I am challenging this CEM and EM, they were getting pension on the basis of notification dated 13/1/21 at page 38. They got pension for about 6 months, then thereafter the pension was not paid. And Karbi Anglong and BTC, they are getting it. So at this stage, my lord, the notice has to go.
How many petitioners are there?
33, my lord. Their details are there at page 15.
They are all former CEMs and EMs
Yes, man.
of NC Hills.
NCLs.
Heard Mr. B.D. Das, Learned Senior Counsel, assisted by Mr. H.K. Sharma, Learned Counsel for the writ petitioner. Writ petitioners peruse the amendments made in the writ petition. The 33 petitioners herein are former CEMs stroke EMs.
Accepting petitioner number 18, who is the son of CM. They are also entitled to get.
As well as the dependent son of CM, former CM. They have approached this court by former CM under the North Kachar Hills Autonomous Council, being aggrieved due to stoppage of the pension and other retirement facilities. The petitioners have approached this court by filing the present writ petition seeking a writ of mandamus. Mr. C. Sharma, Learned Standing Counsel for
Respondent number 1, 2, and 3, Lordship.
NC Hills Autonomous Council, appearing for respondent numbers 1, 2, and 3, has prayed for some time to seek instruction and file affidavit. In view of the above, issue notice of motion returnable on 4th of August 2025, since Mr. Sharma has accepted notice for respondent numbers 1, 2, and 3. Mr. D. Bora, Learned G. Assam for respondent numbers 4 and 5. And Miss, I'll write your name today. What is your name? And Miss A. Bhattaku, Learned Counsel for respondent number 6. Service of notice deemed to be complete in this case. Extra copy of the writ petition, requisite in numbers be furnished to the Learned Departmental Council so as to enable them to obtain instruction. Is there any interim prayer?
No, not now, my lord. The notice has to go, my lord.
Achha. Hard on the prayer of interim relief. The prayer for interim relief will be considered on the return of date.
Oblige. Keep the
Seeking regularization in Fish Feed Corporation. It has already issued notice in 9 matters, the last 10.
Take down hard Mr. P. Bharadwaj, Learned Counsel for the petitioner. The writ petitioner is serving as a driver, so chowkidar under the Assam Apex Corporation Fish Marketing and Processing Federation Limited, bracket close, a bracket of fish fed, as a fixed pay worker, being aggrieved due to non-regularization of his service. The petitioner has approached this court by filing the present writ petition. Stop. Mr. Bharadwaj submits that similar writ petitions filed by similarly situated petitioners are pending disposal before this court. In view of the above, issue notice of motion returnable in 4 weeks. Mr. P. Sharma, Learned Standing Counsel for This is what, AFDC?
The Fishery Department.
Fishery Department has appeared and accepted notice for respond number.
4678.
Respond numbers 4, 6, 7, 8. It'll serial is up. Who is for one? Who is from Mr. D. Bora, Lanet G. Assam for respond number 1 and 1 and 1. Only one. Then who's for finance? Miss A. Botaku, Lanet Council for respond number 2. Miss, you're for?
Lordship, 3 and 5 corporate department.
Your name,
Mr.
please?
Viraj, on
Yeah.
behalf of Mr. Viraj.
Your name, please.
EC Whitefield.
Naam to Miss so-and-so for respond numbers 3 and 5. Mr. P. Sharma, Lanet SC, Fisheries Department, Assam for respond numbers 4 and 6 to
4678.
4, 6, 7, 8. And anybody for 9 and 10? And service of notice deemed to be complete on respond numbers 1 to 8. Extra copy of the read petition requisite in numbers be furnished to the learned standing council so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon respond numbers 9 and 10 by registered post. List this matter along with WPC number.
My lord, 2262 of 25.
2262 of 2025.
Oblige.
Item number 23.
Will issue notice.
Yeah. Notice has been issued.
Notice has been issued. Lord Mr. A. Dasgupta, Senior Counsel, assisted by Ms. B. Das, Counsel for the petitioner, peruse the amendments made in the writ petition. The petitioners are aggrieved due to the impugned order dated 31/12/2021, affirming the instructions issued by the earlier order dated 21/9/2021, whereby directions 29/1/2021, whereby directions were issued to make recovery from the petitioners. Full stop. By referring to the pleadings in the petition, Mr. Dasgupta submits that the ground on which the recovery has been ordered is wholly arbitrary and illegal. Full stop. Miss, your name, please?
D. Pegu.
Ms. D. Pegu, Learned Counsel appearing for the respondents to.
BK Singh.
Huh?
Appearing on
Mr. BK Singh, Learned Standing Counsel, FCI praise for. Where is Mr. BK Singh?
He's
Huh?
out of station and attending another.
So and so appearing for Mr. Ms. Pegu appearing for Mr. BK Singh, Learned SC, FCI. Praise for some time to obtain instruction and the NOM 4 weeks since the Learned Standing Council FCI has appeared for all the respondents, no formal notice, extra copy of the writ petition be furnished to the Learned Standing Council to obtain instruction and file affidavit. Office to list this matter along with WPC number. Sorry?
3153/2021.
3153 of 2021, which is stated to be analogous to the present proceeding.
Item 28.
When I filed their affidavit, I've been informed that council is on legs, Lord, but take it after some.
You don't want to file any reply.
No, Lordship, it's been covered by your Lordship judgment.
Finding item 18.
May it please your lordship.
Yes.
Lordship, the petitioner was employed under BHPCL in 1994. And that is at annexure 1, page 24, madam. Thereafter, there was an acquisition and transfer of the employees by the state of Assam. An act was passed wherein the entire staff of BHPCL was acquired by AECB. And my lord, thereafter a commission was set up where Mr. Lordship, retired Justice D.N. Borua was the commission member, where the order was passed by the commission that the entire process of these people who have been employed by a BHPCL and now been acquired by ACB would be an employee of government of Assam and they would be giving the entire benefits as per the government order. And accordingly, thereafter,
We'll issue notice
My
at
lord.
this stage. Mr. S.P. Sharma, our counsel for the petitioner, peruse the amendments made in the writ petition, full stop. The petitioner is a former employee of now defunct Bharat Hydro Power Corporation Limited, bracket BHPCL, full stop. By filing this writ petition, the petitioner is praying for a writ of mandamus, directing the respondents to grant him the benefit of pension under the old pension scheme, as well as death cum retirement gratuity, bracket DCRG, bracket close, by treating continuity of service. Full stop.
But
Mr. D.
he-
Nath, Senior Government Advocate Assam, appearing for respondent numbers.
For all the respondents.
All the respondents has prayed for some time to obtain instruction and file affidavit. Prayer allowed NOM 6 weeks since Mr. Nath has appeared for all the
Yes,
respondents, no
it is
formal
landscape.
notice, extra copies, etc.
Otherwise, my lord, he retired in 2023
That's right. He's a former employee.
from an employee.
from APGCL. No?
APGCL.
APGCL.
APGCL was undertaken by Government of Assam.
Lord, I
And
am appearing,
subsequently, former employee so-and-so and subsequently employed by the APGCL.
Much of that.
on the ground.
19, item 19.
My lord, I'm appearing for respondent number 2, 3, and 4, my lord.
So what do you have to say? Suddenly you have reduced his, and
Madam,
you're
yes,
not
I have-
paying him salary, why?
Yes, madam, I have seen, madam. There is a, madam, the order dated 7/5. The impugn order has been challenged, madam, at page 63, madam. They are challenging that order, madam,
The impugn order at page.
63.
But why are you not, why have you stopped his salary?
That I have not taken instruction, madam.
And one more thing, your lordship, just before, just point out here only paragraph, this judgment, recent judgment, like this. Para 26, your lordship, they cannot do that. Very specifically given. After
No,
considering.
what do you want, a notice or
This
he
is
should,
Notice, but at least my interim prayer, your lordship, his salary may be.
that
That
then
will
he
not
has
be
to
problem.
get, obtain instruction then.
No, at least the salary, regular salary. may be.
Oh, unless he obtains, there can't be a expert mandamus. He has to be given some time to find out.
This is okay, your lordship, I'm not on that. I'm saying that, yes, let him take out whether the order that is at page 7/5 to 2025, that order, your lordship will decide whether that is correct or not, fine. But why top my regular salary?
We want to know that. That's what I'm telling him, day after tomorrow.
That can be.
Tell us day after tomorrow why his salary has
Yes,
been.
that
Yes, heard Mr. Y.S. Manan, learned counsel for the petitioner, peruse the amendments made in the writ petition.
judgment.
The petitioner is aggrieved by the order dated 7/5/2025, issued by the Director of Employment and Craftsman Training, Assam, inter alia, downgrading the grade pay earlier paid to the petitioner, as well as stopping his salary. Full stop. Mr. Manan submits that since the last month, the petitioner's salary has been stopped and his name has been deleted from the pay slip, thus causing serious injury to the interest of the petitioner. On the request of Mr. S.P. Das, learned standing counsel for the Directorate of Employment, Craftsman Training, Assam, this matter is directed to be listed for motion again as a fixed item day after tomorrow, date to the, so as to enable him to obtain instruction as to why the salary of the petitioner has been stopped. Can you give him 2 extra copies?
Give him.
2 extra copies of the writ
I'll give.
petition be furnished to Mr. Das.
My name will be shown, madam.
Yes, list this case again by showing the name of Mr. S.P. Das, learned counsel for the respondents and the cause list. You, right now, you just tell us why have you stopped the salary?
But I think, madam, since there is a dispute regarding the scale, madam, which is supposed to be 5,600.
So you will stop the salary?
That I will take the instruction, madam. But now question is that, madam.
So now there is a dispute when the director is also involved. Should his salary also be stopped? Ask him that.
Yes, sir. That
Yes.
also, sir.
People are absolutely acting on a
wrong.
very.
It's wrong.
You pay him the admitted
yes,
salary.
yes.
Why have you stopped it?
And I'll take back.
Mr. Manan, day after tomorrow.
Oh, ma'am.
I'll collect that order. Just now I have given that order. I'll keep it with me. Again, I'll let it, give it.
It judgment to go ahead. It was filed or to go ahead.
Earlier order, PHC department, next time for filing affidavit, till now, they have not filed affidavit.
Lordship, affidavit has been prepared and has been sent for vetting, my lord. I
You
just
want some
believe
more
for
time?
it to be fixed on Friday, your lordship.
Friday is not possible. Then let it come after vacation. Let them file the affidavit. You file it by Friday
Your lordship.
and serve copy so that they can obtain instruction and file reply. Miss, your name, please? Huh?
DJ Bora.
Ms. DJ Voral, learned counsel has appeared for the writ petitioner. Ms. M. Kalita, learned standing counsel for PHE Department, Assam, submits that affidavit on behalf of the department has been prepared and the same will be filed on or before 27/6/2025 by serving advance copy upon the petitioner's counsel. As such, a request has been made to post the matter again after the summer vacation. Mr. D. Voral and G. Assam is present on behalf of the state. On the request of Learned Standing Counsel for PHE Department, this writ petition stands adjourned till 18th of July 2025. The Learned Standing Counsel for PHE to file affidavit on or before 27/6/2076 2025 by serving advance copy upon the petitioner's counsel. Yes, you were saying something? 18th of July, it will come. Yes.
Highly obliged, your lordship.
Obliged.
I need some time. File affidavit, lordship.
Can you see the last order, my lord? Interim order was supposed to be last, my lord. But they are special counsel, my lord. They have not filed the affidavit. And my lord, they have proceeded, my lord.
So what is he is seeking relaxation of age?
Yes, lordship, we have rejected it,
Ah,
citing citing the service rule, lordship, we have rejected it.
what has happened now? The results are declared.
No, lordship,
Then-
it is not processed. Even there is nothing has happened. APSC has not started the process interview also. Application is over.
There are two writ petitions.
Yes, my two petitions.
What is the first one about?
My first one is regarding the, my lord, the interim order which they have passed pursuant to this court order.
Hmm.
On that, my lord, that order, my lord, they said that there is no rule. Lordship may come to that, my lord, at page 83, WBC number 2840. Here they said that there is no rule, no such rule. Hereafter, my lord, what they did, they have modified the order. Modified the order, and now they have
You are overaged by how many years?
my lord, 42 years, 42 years, 5 months, 26 days. But my lord, the thing is that my lord, I was working with the department since last 8 years, my lord.
That is
Just before publication of the advertisement, my contact was closed, my lord. That your lordship will find, my lord, that, my lord.
So you were overaged, that you agree.
Yes, my lord, that
Why do you-
I'm overaged. But thing is that, my lord, why they have not considered their own rule? Since there is a rule, lordship has, lordship's own order is at, my lord,
Which is the order impugned? Let us see.
impugn order is at, my lord, page 86, my lord, annex 16 of WPC number, my lord, 2840.
Page 86.
86.
So this is the last order, 5/5/2025.
Yes, madam, this is the last one. But lordship may come to lordship's own order, madam, at page 27.
All right, now, where is your affidavit? Now, as per the rules, 38 year is the
Yes, madam.
cutoff. Relaxation is required only when somebody is more than 38 years. So court says consider his prayer for relaxation. You come back saying that because 38 is the cutoff date, we cannot consider. One post has to be kept vacant. This order will be set aside. That is why relaxation. Your officers have not understood the order of the court at all. Is it not? 38 is the last.
Yes.
That is why he is before the court.
Lordship.
Relaxation question will arise only when someone has exceeded the age.
Lordship.
Relaxation can be granted, may not be granted. The court will not say anything. But if the exercise is fair, balanced, non-arbitrary, matter ends there. This is an arbitrary order. The direction of the court has not been complied with.
But law.
One post you have to keep
But the
vacant.
law says there is no 38 years is the cutoff year.
Which law?
Well, our service rule says that. And
That's why the court has said. So you are saying somebody who is below 38 years, his age can be relaxed. Is that the stand?
No, that is not.
Then what is the stand?
But we cannot.
Heard Mr. SP Das Lanik counsel for Mr. Mahanta, do you want to say anything? Anything you want to say? Yes, yes.
It is already 30 years old. There might be 5 reasoning government reject it after the government. After 38 days.
That's why, so matter will require examination. For now, we'll protect his interest, keep one post vacant. Go ahead. One post, that will tell them. One post has to be kept vacant. See, if they would have considered the prayer properly and given a good order, the matter would have been over. The government, 90% time, the government invites litigation. Either knowingly or unknowingly, we don't know. Oh, court says consider whether his age can be relaxed beyond 38 years. And the government says no, it cannot be relaxed because 38 is the cutoff year. Huh? What kind of a stand is this?
Yes.
He cannot fill up the form, that's why he was not considered. Now he's in there probably vacant ballot can be purpose. He want to get in the participant in the examination part. Fine, if my lord is not yet been my lord, it can be allowed to sit in the.
Then why don't you provisionally allow him to sit?
If the my lord, he also sleeping my lord, what a matter my lord, after last day he approached this honorable court. The lordship kindly see that I have.
What was the last date?
Last date was 23rd March.
March was the last date of the submission of the application. He approached this honorable court on 25th March.
And when was the impugn order passed? What is the date of the order?
They have not.
No, Mr. Das, take your seat. Take your seat. No running commentary is permitted in this court. Yes. The last date for submission of application was 23rd of March 2020.
23rd of March, man.
Okay. And when was the impugn order passed rejecting his prayer?
34, my lord. First one is 34, my lord. Second one is 22/5/2025.
So that was after the last date was there.
After the last date, no. He even filed his writ petition after the last date, my lord.
Look, there are two writ petitions. The
My
earlier
lord,
one
both the
is,
writ petition are filed, my lord, after the last is over. So,
let us see the other writ petition. This is filed on 26 May.
my lord.
Where does one find the last date of submission of application? Where does one find last date of submission of application?
Advertisement, no?
Yes.
Your lordship will find it page, my lord, page 28. WPC 2840, page 28.
Yes. Where is it written? Last date?
Page 28, my lord, starting date for online 20, closing date for online application 23/3/2025. Last date for payment of application 25/3.
To that,
You want to participate in this election?
I want to participate.
Wait. Why have you come after the last date is over?
That I'm saying, madam. That I'm saying. Not, I applied online on 20 March 2025, madam. That is annexure 5/8/33. My candidature was not accepted. So I immediately approached this court. But after 20 March, but I filed this first petition on 24th March, madam. 2 days is required, madam, for filing a petition, madam. He immediately approached me, madam, the petitioner. And the first case was listed before this court, madam, by mentioning it, madam. Showing the
No,
address.
the online application was opened on 24th of February.
Yes, madam. I applied on 20 March 2025, madam. But it got may kindly see page 33, madam. They're not accepted.
But after the online date is closed,
No, madam, before that, I
all right, we'll issue notice, but you will not get any relief here. There are judgments of Supreme Court.
madam, kindly see, madam, our High Court's order is there, madam. Kindly see, madam.
Yes. What High Court order is there?
Madam, page 70, madam. Page 70, WPC number 7655 2018. Also, may come to page para 9,
Page?
page 72.
Yes.
May I read, madam? Para 9. Down below, madam. If the rule is silent about the relaxation of the age in respect of certain any dates, it does not mean that the authority is devoid of any power to relax the upper age limit. The power to relax the service condition is inherent with the appointing authorities. Some of this power is expressed by way of publication of rules or OM, as the case may be. However, it does not mean that in absence of any publication of rules, the authority do not have the power and cannot relax the service condition of the service rule. The only requirement is that it must be done in a fair and non-discriminatory manner by notifying it. But it is there, madam. One another doesn't is there, madam. Here, madam, I have.
And in the rules, which is the power for relaxation?
Yes, madam.
Rule number?
26, madam.
Rule 26.
Rule 26. Page number, madam. Page 67, madam. Rule, sorry, madam. Rule 25. In the provision, it says so, provided the case of any person shall not be dealt with any manner less favorable to him.
And these rules lay down the upper age limit.
Yes, madam.
Clause number?
Clause number.
7.
Madam, page 61, madam. Page 61, madam. Rule 7.
So what is to be done here? Tell me.
I come with a solution if you public subject to consumption. Let it be day after tomorrow. If he can accommodate, my lord, I'll ask them if, because already process has started. If you offline application, my lord, he may be best. He want to take a chance, my lord, probably. If he fail, goes. If he want, if he pass, then my lord, it will be. I'll take instruction.
We'll pass an order directing them to accept his
offline. Offline and because already, my lord, process has been started, but probably date has not been fixed for interview. So, my lord, day after tomorrow, my lord. My lord.
Otherwise, what happens is some wrong by the government
Actually,
also.
that order passed by, I am also not satisfied because
Then we'll have to pass.
because 38 is the last year. That's why I'm not considered. Cannot be, my lord.
That
Because
order is
relaxation after 38 only, my lord.
Or Mr. SP, there's no counsel appearing for the petitioners Also had Mr. T.J. Mohantal, learned senior counsel appearing for the APSC authorities who seeks posting of this matter again day after tomorrow, that is, give the date, so as to enable him to obtain an updated instruction. Mr. P. Sharma, learned standing counsel for the Fisheries Department, and Mr. R. Dhar, learned additional senior government advocate Assam, are present on behalf of the respective respondents. We'll see. Just see whether
My
we'll
lord,
pass an order and offline.
Definitely, if it is not over, my lord, definitely accommodate, my lord.
If the suspension was not reviewed within the statutory period of 90 days, they had filed their own.
We have filed the affidavit. So
Same
same issue, my lord, only the date of suspension is different and the designation of the petitioner is different.
Page
Otherwise,
55
same.
is your lordship order.
Hmm?
Page 55 is your lordship order.
Actually,
So the other person has been reinstated.
reinstated and a common inquiry is now going on against both of them because same allegation, same branch. Only these two differences would be there, my lord. The date of suspension is 29/5/2024 instead of 23/5/2024.
And he was working as a office assistant
Office assistant, and the
in place of branch head earlier.
the earlier petitioner was,
Was
my lord,
working as a
branch manager. So these are the only two differences. Otherwise, lordship.
And the other petitioner was branch manager.
Branch
head.
branch manager.
All right, take down. Heard Mr. H. Agarwal, learned counsel appearing for the writ petitioner. Also heard Mr. A. Ganguly, learned standing counsel for Assam Gramin Vikas Bank and others, bank appearing for the respondents. The writ petitioner herein, who, while serving as office assistant in the AGVB, this is what, Tinsukia branch?
Borguri branch.
Borguri branch.
Tinsukia district.
In Tinsukia district was placed under suspension by order dated 29/5/2024, and thereafter he was subjected to departmental proceeding on the charges of gross misconduct along with another employee of the bank, namely
Arup Seike.
Sri.
Arup Seike.
Where is the order of the court?
No, it's page 55, annexure 12 of the writ petition. my lord.
Namely Arup Seike, who was serving as the branch head of the said branch at the relevant point of time. The case of the petitioner is that his suspension has been continued without carrying out proper review within the prescribed period of time, that is 90 days from the date of issuance of the order of suspension. Full stop. Next para. By referring to the order dated 28/5/2025 passed by this court in WPC number 2666/2025, wherein this court had issued a direction to reinstate the petitioner therein, namely Sri Arup Seike. Mr. Agarwal submits that the case of his client is covered by the said judgment, and therefore a similar order be passed in the present case as well. First up. According to Mr. Agarwal, since the petitioner and Sri Arup Seike are facing a common departmental proceeding on self-same charges, hence a differential treatment to both these employees of the bank are not called for. Full stop. Responding to the above, Mr. A. Ganguly, learned standing counsel for the bank, is referred to the counter affidavit filed on behalf of the respondents and submits that there is no policy for the bank to issue any communication to the delinquent officer pertaining to extension of the order of suspension. Mr. Ganguly has, however, fairly submitted that pursuant to the order dated 28/5/2025, Sri Arup Saikia has been reinstated and the departmental proceeding initiated against Sri Arup Saikia and the petitioner are one and the same, and therefore it cannot be, therefore it is correct that the order dated 28/5/2025 will have a bearing on the prayer made in the present writ petition as well. Full stop. Next paragraph. In the order dated 28/5/2025, this court had issued the following direction. Page 58, you will get it. Page 58. Full stop. Since there is no controversy at the bar that the petitioner is also similarly situated as Sri Arup Saikia, with the only difference being that the date of order of suspension issued to Mr. Saikia, issued to Sri Saikia, was on 23/5/2024, and at that time he was serving as the branch head of Borguri branch, Tinsukia. All other facts are common in both the cases. In view of the above, this writ petition stands disposed of in the light of the order dated 28/5/2025, with a direction that the petitioner herein be also forthwith reinstated in service. However, the liberty given to the bank in case of Arup Saikia, as noted in order dated 28/5/2023, shall apply in case of the writ petitioner as well. With the above observation, the petition stands closed. এটা পাস ওভার কোশ্চেন কি ব্যাপার ম্যাটার পাস ওভার